Today I'm going to cover all the questions on the channel. I've also launched a new channel today, Simply Sachin 365, which is more of a personal channel, giving all the information about my life lessons, learning, various advice on other aspects of life other than UK immigration law. So that's more of a personal channel. If you do like that, please do subscribe to that channel. You will have the link in the featured in the channel description of the featured channel, or I will also put a card possibly on this video and other videos. So please do subscribe to that channel if that is of interest to you. I've already published one video today on savings, etc. Yeah, if you do like it, do subscribe to that. I will start with the on this channel on UK immigration law. I will start with the questions on the channel. Yeah, so and if anyone comes live, you can ask your questions. So the first question is Tiva, you got your sponsor license after 4 weeks. Copies of official contracts and yeah, so Tiva, the question is about you. Your sponsor license was approved, and I'm pretty sure you applied for a defined certificate of sponsorship, and hence that standard email has come to you. Not everything will apply to you out of that standard questionnaire that Home Office sends asking you to, because they are trying to do a remote audit. It's called as virtual audit that Home Office does when they do it usually for when you make a Decost request. That's what I've seen. So they want to see that everything is genuine. In your email, what you're saying is what they've asked for: current official contracts, agreements, business, genuine vacancy. Yeah, they want to see that you have enough money to pay the salaries, you have enough work for the employee, etc., etc. So whatever you can prove, you have to prove. They should include contracts, demonstrated, guaranteed. So why do you need the migrant? That's the question basically, to provide services. What work do you have? Do you have enough money to pay the salaries, etc., etc. Contracts. Yeah, they want to see how much business you are really generating, whether the vacancy is genuine. So this is quite a common thing. You will have to provide whatever evidence you have. Most probably speak to an immigration lawyer and see what applies to you. I know they have asked for a lot of information. Some things will definitely apply to you. It is impossible that nothing will apply to you. So make sure speak to an immigration lawyer and get it deciphered. And that's what I can suggest. Okay, live question. Munawar, dependent rules for students. Those who are already in the UK, can they continue to switch any visa? Dependent rules for students. Dependent rules for students. Sorry, I don't understand your question clearly. Dependent rules for students. Those who are already in the UK, can they continue to switch to any visa? Yes, technically, students can switch to any visa provided they have completed the course of study. You will definitely have the restriction into switching into anything. So, about for dependents of students, yes, they can switch into any visa. Next question, then Jagur. My son is studying in the UK for last 7 years and he is under 18. What's possibility for getting under 7 years private life route? What's Yeah, if your son is not born in the UK, the 7 years private life route for ILR does not apply to him, so he will not qualify for ILR. I'm assuming he is not born in the UK, studying in the UK. That's what you said. Okay, Sani Ali. Hello, sir. I came to the UK on a student visa in 2011 and overstayed till 2017. Then left the UK in 2017. I'm going to apply for skilled worker visa with my previous history of it. Yeah, from 11 to 17, from 2011 to 2017, you have overstayed in the UK. Sani Ali, you left voluntarily, so you will have 12 months ban from the point you left. It's more than 12 months now. You can apply for any eligible visa that you want to apply, visitor visa, skilled worker, if you meet the requirements. They will, that overstay will not affect per se, but they will definitely check whether the vacancy is genuine. Everything on the current application is genuine. The skilled worker, if you're trying to buy a course or whatever you are doing, they will be testing you quite carefully. If everything is genuine, you should not be worried about it. But if there is any wrongdoing, any buying, selling, anything going on, they will refuse it, I'm pretty sure. So they will check the latest application carefully because of that overstay. But because of that overstay, they will not just refuse the application, but they will check the application carefully. Okay, next question. on the channel. I'm on skilled worker visa. My company, I completed hours of working as promised, but last month I was sick, so month may not complete hours, but then it will be a me any solution. Okay, so the question is about, I think, skilled worker or care visa. So your company, you have been working regularly with your company. Last month you were sick and you were not able to do whatever the contracted hours are. Sickness and all this can be accommodated if it is in a reasonable sense. I think it's only within a month's time or maximum month. It should be fine. I don't think it should have any impact on your ILR if it is for a reasonable period. In your case, you say under a month's time. Okay, next question. No lie. I have a question if you'd like to answer. Will my previous overstaying history affect the outcome of re-entry on a skilled worker visa? I think Sani Ali, I answered your question live, so that's the same question you have asked on the channel. Okay, is it true that Home Office is not giving costs? I cleared the interview, but my agency is saying that as immigration rules are changing, companies not ready to apply for costs. No, from hospitality. That is not true. Home Office is giving costs. We are getting costs, whether D costs or allocations of undefined costs. They are giving it all the sectors, but they will check. That is what, because of a lot of frauds happening on various sectors, care area, building, construction, and whatever, hospitality, etc., etc., restaurants and all. Home Office is very carefully looking at every causes. That's what the first question was. Someone is asking for, I think you are a shopkeeper or something and you got a license. You asked for a DCOS and they asked you a long list of documents about everything. So it is common. They will go back to the sponsor asking for all the things. They are doing these remote audits with many sponsors, especially in these high risk areas. You are also in hospitality. So it is not that they are not giving the courses, but yeah, if it is not a genuine thing, obviously your employer will not try, or there may be some issues. But if everything is genuine, they will give the cost. Yeah. So that's what I can say. Next, in addition, okay, you can also from India, some people by your business. Okay, I have answered your question in the previous live. I got the student. So regarding the self-employment, okay, so the question is, I'll just address this. So Vikram Shri, I think you asked this question in the previous live also. Uh, so the 20 hours additional work on a skilled worker visa, it is either in the, it should be in the same occupation code and at the same level, and it cannot be self-employment. I think you're trying to assume self-employment. No, it cannot be self-employment. Next question, I got the student can change into dependent visa after completing study, but if student work more than 20 hours in 2-3 weeks, the problem while changing into dependent visa. Yes, so if you have breached the conditions of your leave, so in your case, you are saying you are a student, you want to switch to whatever the next visa is after completing your study, your course, you have worked 2-3 weeks extra over the 20 hours. My advice is don't breach the conditions of work. Careful. Home Office is catching everyone canceling student visas. This is a common practice going on, and that too with immediate effect. They are canceling the visas. I have seen many refusals where clients are showing me those refusals and asking what can be done. Nothing can be done once you have breached the immigration rules, the conditions of your stay for a student. If it's 20 hours work, it is 20 hours work. Very simple, plain English. So if you have worked 2-3 weeks extra, if they find out, yes, it may be a problem, but I'm not sure whether they will find out just one instance of overworking. It depends on your luck. Okay, next. Chirag, can we get Amazon voucher, Amazon warehouse, skilled worker visa? It doesn't matter who the employer is, whether it's Amazon or whoever. If it is eligible for the skilled worker visa, they should check the job codes and all which are eligible, the minimum salaries, whatever they are willing to pay. If that is fine, whether it's Amazon or any other employer, Home Office cannot discriminate against employers. If you are eligible, you can apply for it. Okay, hi sir, I have a doubt. I got job offer. I was 25,147. I'm going date for that 24,200. I apply for the visa. Will I get rejected? Okay, so Joseph Thomas, you have got a job offer with salary as 25,147 and the occupation code is 24,200. Unless your job is in some kind of a discounting, whatever that is, shortage occupation, new entrant, salary, etc., I don't think you will qualify because the minimum salaries are 26,200 if I'm not wrong, and your salary is 25,147. But I am not sure. You should check with your employer whether your job code is eligible for any discounting. So unless your job falls on any shortage occupation or something like that, or PhD occupation or new entrant, only then you would qualify for that salary. Next question. Hello, sir. Me and my husband are ready on PSW and want to switch to healthcare visa. So, can my husband stay with me if I switch? So, you and your husband are on PSW visa, so you are the main applicant and want to switch to healthcare visa, which is a skilled worker visa. Can my husband stay with me if I switch visa after these new rules? If you switch the visa to the care worker visa after the new rules are changed, whenever they're changing, so you will not be able to sponsor your husband. So your husband will have to leave the UK. That is what the rules are as of today. So you should switch as soon as possible before the rules change. If the rules change and after that you have switched to the healthcare or skilled worker visa, your husband cannot continue living in the UK. So next question is, I applied for Decost on 21st century shopkeeper. Still home office does not approve. When I called them, they said some jobs for time. Is there any, do you get defined cost quickly? Yeah, so the question is, can you get defined cost quickly? No, you cannot get defined cost quickly. There is no priority service. The standard processing for normal courses with no issues of compliance and all is about 2 weeks. We are getting in 2 weeks with most of our employers. But if Home Office wants to investigate further, I know they are taking more time for care worker areas and hospitality and building sectors. They are taking 3 months, 6 months also, that I'm aware of. But the standard processing is about 2 weeks time for a DCOS on a higher end. I've also got DCOSs in 3-4 days. So that is normal. But if Home Office is trying to investigate the matter, either the sponsor license, the job, genuineness, anything and everything, they will take more time. So you applied for DCOS, and yes, it may take more time. As Home Office has said, I think you called the business help desk. They may have told you there are delays on some specific types of DCOSs or some specific job codes that Home Office is trying to investigate. UK skilled worker visa for a new entrant. Can you please clarify that a person should be 26 years and recent graduate, or only recent graduate can be accepted? I'm like 30 years old. Recent graduate. I think for the recent graduate visa, you need to be under 26 years of age. To the best of recently graduated as my master's and working in the salary. So new entrant, to the best of my knowledge, let me check. I will just try to check. To the best of my knowledge, don't think you can apply, but still let me check. Skill worker. Okay, live question. I'll take that first. Let me just complete this one. A new entrant to the labor market. Okay, what do I check? Yeah, for the new entrant visa, I'm pretty sure you should be under 26 years of old, 26 years of age. At the age of 30, new entrant, let me check. Just 12.1 to 12.5. Let us see, 12.1. No sponsored a job appropriate, administration of the following categories: 26 years old, job or this job. Profession must be working towards full registration, must be permission to stay for permission to, and the applicant who permission must have a one no of the following conditions apply. No, if you are 30 years of age, you cannot apply for the new entrant salary, new entrant visa, technically. So my answer is no, you are 30 years of age, you cannot apply for the new entrant visa. Okay, Ritul's question. I'm working on a recruitment administrator in a home care company. I'm eligible for skilled worker visa. My employer tried sponsoring me, but they said I'm not eligible. My salary is 25,000. The minimum salaries for the skilled worker should be okay. Okay, you cannot be sponsored for that administrator job. I'm pretty sure it's not in shortage occupation or any other discounting does not apply to that. Minimum salary is 26,200 for 37.5 hours working week. So that's the reason your employer may be saying that they cannot sponsor you with the 25,000 salary as a recruitment administrator. That is the answer, Ritul. The Jaguar, hello. I checked on government side and it says if your son who is not born here, but if they continue to stay here for 7 years, then he's fit to get visa for 2.5 years. My question is one. Yeah, I don't think that is correct. Your interpretation of whatever you're trying to say, your son is not born and just living in the UK 7 years, it will be a discretionary application. It will be a 50-50 chance of success. But I don't think there is no provision in the rules with what you are stating. Your son is not born in the UK, studying in the UK for 7 years, and you're trying to apply something under the family route, either ILR or the 2.5 years of permission. 50-50 chance of success, it will be on discretion. There is no clear provision in the rules. Hi, sir. Okay, Mr. Sekon, next question. We are waiting for our costs for carer and still there is nothing from last 4 months. Is possible? As we saw, there is some issue from HO. Yeah, they may be trying to investigate whether everything is genuine. On the care worker side, there are companies who are waiting for 6 months and all. It is common. They may be investigating. You can check with the business help desk and call them and or email them and check with them what is the status. They may have already sent you some further information request. If not, maybe check with them. But the queue is quite long with the care worker visa area. Whatever Decost you may have applied, yeah, so there is a delay that's everyone is aware of, we are aware of. Nothing that you can do. You may have to just follow up with the business help desk and cooperate with them with any virtual audit that they wish to do with all the information that they are asking for. That is the only thing that I can say. Sorry about that. Okay, next question. Or maybe if you have an immigration lawyer, ask your immigration lawyer to follow up with the business help desk or the relevant teams as to what is the issue going on. Maybe if you engage with a rep, it may help. Okay. Next question on the channel for new entrant. Can you please clarify that a person should be 26? Okay, I've answered that. Will not qualify. Is there a cap limit on the number of skilled worker visa students visas can be issued in the UK? Okay, the question is there a cap on the number of skilled worker or student visas to be issued? No, there is no cap as per the rules, whether on skilled worker or on student visas. Do you do parents dependent ILR visa? What is the best contract? Okay, so dependent parents, adult dependent relative. This is a common question that we get, so I will just address on the channel. People try to write and get some answers on this. Uh, Dependent parents is not an easy area. Last year, we had through our Immigration Lawyers Association, we had taken all the data to the subject access request from Home Office. Dependent parents, there was less than 5% of the applications were successful. The rules are very strict since 2012 July. The rules had changed for the adult dependent relatives. If you're trying to apply for ILR for a dependent relative, the two main strict conditions are that there is some specific care that they need and that care is not available in that home country or that is not affordable. It's very difficult with usually with Asian countries and all. I've seen that, but yeah, if you want to consider and if you want to take our advice on your specific case, then you can check our bio page and there should be an email in the contact information. You can write to that or visit the website. Everything is in the channel link. You can get our information from there, from the channel bio page. Okay, thank you, Mr. Sekon. So all the questions on the channel are completed. There are no live questions. So I will end this live and thank you very much for joining. I have today launched another channel which is not on UK immigration. It's more a personal channel. I will address your question, Mukesh. So it's simply Sachin 365. It's more about everything about me and various other aspects of life. If you are interested, the link will be in the bio page of this channel or maybe in the cards that I will add to this video. Mukesh Raja, my girlfriend is British citizen. I'm currently living in India. What are the quickest ways visa? What are the quickest way to get married before the rules change? Applied because the salary range is below 29K. Should I travel there? Yeah, you have two options. Either she travels to India, gets married to you immediately, and immediately after that, you apply for the spouse visa. She should be earning at least 18,600 or higher. Okay, that's number one. Or you apply for a fiance visa, show her last 6 months of financial documents, salaries, pay slips, bank statements, etc., letter from employer, and apply for a fiance visa, come to the UK, and then get married. These are the two options you have, Mukesh Raja. Ritul, just for clarity, they are okay to give me an appraisal, but I am quite not sure that recruitment administrator position is eligible for skilled worker visa. The position will be eligible. I'm very positive. I've done something like this in the past. So yes, uh, recruitment administration, there is recruitment consultant or some job code is there. I'm aware of that. So if they are willing to give you the higher salaries, whatever are the minimums, I will anyway check it for you. Just a minute. I should have the job code here. Where is the shortage occupation, going rates and recruitment? Okay, recruitment consultant. Yeah, human resources. So minimum salary of 26,200 if I'm not wrong. What is it? Just 1 minute. Yeah, so if they are willing to pay you 26,200 per year for a working week of 37.5 hours per week, then you should qualify for the skilled worker visa. So that is the answer, Ritul, to your question. Mukesh Raja, thanks. So for the from fiance visa, once after the marriage, I should apply for spouse visa. Yes, you are right. Once you enter the UK on a fiance visa, get married to your fiance, then you can apply for the spouse visa. Franco CB. For a non-UK born kid living in the UK for 7+ years continuously has 50-50 chance, as you mentioned, lives and property in India. Does this affect further? To the best of my knowledge, it is a difficult one. I would even rather just living 7 years in the UK may or may not. It depends on the age of the child, how much time the child has spent outside the UK, in the UK, etc., etc. Where are the parents? A lot of things are into consideration. I cannot give you an answer. So, yeah, so it is better you speak to an immigration lawyer, give them all the facts of the case, and then they may be able to advise you on what is possible, what is not. There are many factors on these human rights applications, so it would be wrong for me to give you an incorrect answer on this forum. So Moni P, what is the grace period for Decost? My agent is saying that government might give grace period of 3 months after April. Is it true? I don't understand what you mean by grace period. Please clarify. So after April, I don't know what does that really mean. There is no such grace period term that is being used in this reference. If you are saying that, maybe one of the interpretations, you can clarify in the comments whatever you can, Moni. So if you get a DCOS approval and after that you apply when the rules change, that we can only advise you once we see the new rules. Only then we can advise you what they are doing with the DCOS which is already approved but which is under 38,700, and how are they going to deal with it. So thanks for verifying. I haven't got a clear date yet from our Immigration Lawyers Association, but sometime around April. I know there are different dates floating around. I saw some other videos or some information. I'm not going to give you a wrong date of change that is going to come for all these changes from autumn. Sometime in April, I think that's what is proposed, but I don't have an exact date as of today for the change to any of these, where dependent of care workers, skilled worker increasing to 38,700, or the third one, spouse visa increasing to 29,000. I don't have an exact date as of today. Rules have not been published yet. Thank you very much, everyone, for joining. And I'll do another live maybe this week or next week. Any questions, please ask them on the channel. Thank you.